Welcome to the Arts Council of New Orleans' latest webinar, Community Property and Intellectual Property, featuring Liz Meneray. Now, before we begin, I'd like to thank our sponsors for today's webinar, the Emily Hall Tremaine Foundation and the Joan Mitchell Foundation, and to remind you that your support, along with the support of our funders, helps keep this information free. At the end of today's presentation, you'll see a link to donate to the Arts Council of New Orleans, either by becoming a member or simply by making a contribution as small as $10 via our Facebook Causes page. Now, if you're joining us live, I'd like to direct your attention to the live chat box at the lower left corner of your screen. If you have a question, please type it in that chat box, and Liz will answer it in real time. If you're joining us on the archive version, Elizabeth's contact information is available at the end of the presentation, and I'm sure she'd be happy to hear from you. Now let's begin. Thanks for joining us today, Liz, and welcome.
Hello. Thank you for attending this webinar concerning the treatment of intellectual property under Louisiana community property law. I'm Elizabeth Meneray, and I began a law practice dedicated entirely to the law of families. My focus is on the relationships that start and end within families. That entails not only the relations of husbands and wives in marriage and divorce, but also parents and children in the contexts of adoption, child custody and support, emancipation and tutorship, and at the end of life in terms of powers of attorney, wills, and successions. My office is located in Mid-City, just one block off Canal Street at 146 North Telemachus Street. Please feel free to contact me by phone or email anytime. The purpose of today's webinar is to better acquaint married Louisiana artists with the laws affecting the products of their artistic endeavors. Whether you paint, sculpt, compose music, or write screenplays, if you're married in Louisiana, you're affected by its community property laws. If your art is covered by a copyright, you're also affected by federal law over how you may manage that copyright. Married artists in Louisiana may be affected by both state and federal law when divorce and copyright meet head-on. To begin, let's take a look at Louisiana community property law. Our civil code has established that the default marital regime under which all married persons live is the community property regime. That means all married persons, unless they have made other contractual arrangements, live together subject to the laws of community property. Now, I'm certain that you have a general idea of what community property is, but there are several ways that property can become community during the course of a marriage. This seminar focuses on one in particular, the product of work. The Civil Code partially defines community property as the product of the effort, skill, or industry of either spouse during the marriage. That means basically that the work you produce through your effort, skill, or industry, as well as the money you make for that work, belongs not only to you, but also to your spouse in 50-50 proportions for the time that you're married. I have in past discussions likened the situation to a fruit-bearing tree. When you're single and own that tree, all of the fruit produced by that tree belongs to you. Once you become married, the tree is still yours, but the fruit it bears belongs to both you and your spouse. There are ways to ensure that those fruits remain your separate property, and we'll discuss how you can do that in a little while. The community property of a married artist and his or her spouse is defined in the same way as for non-artist couples. But artists should be aware that the law extends the definition of community property beyond the marriage for certain products of your effort, skill, or industry. For instance, you produce art for a living and you hope to sell the work you make. But in the course of producing that work, you build up inventory. The inventory may take some time to sell, but the work itself is the product of your effort, skill, or industry during the marriage, even if the work you produce isn't actually sold until after the marriage ends. The money you earned for that work after the divorce is still community property because it came from selling a thing you produced during the marriage. This is an important concept to understand because it affects how you perceive the value of the community at the time of the divorce. If you are going to continue earning revenue from artwork produced during your marriage, you have to make arrangements to continue sharing that revenue in equal proportions for as long after the divorce as is necessary to deplete that community asset. As you well know, art is a difficult business, but some of you will have the good fortune of being quite successful with your work. The fruits of your community tree may multiply considerably over the course of your marriage, and your name may become synonymous with an iconic figure from your work. Take, for example, a big blue dog. We have one artist here in Louisiana whose marriage and divorce set the stage for the rest of you in terms of how some art, particularly that bearing copyright protection, is treated under Louisiana marital law. But before we go into that seminal case, let's review the basic principles of copyright law. As many of you already know, your original works of authorship, when they meet the criteria of federal law, can be copyrighted with the Library of Congress. Generally speaking, the copyright gives its owner the exclusive right to reproduce, distribute, perform, display, or prepare derivative works based on that copyrighted material. The copyright lasts throughout the author's life, plus an additional 70 years for an individual. If you've watched the very informative webinar presented by attorney Ashley Keaton of the Arts Council's Ella Project, you've learned how to register your work for copyright protection. Obtaining this protection is an excellent way to preserve your work from legal challenge in the future, whether those challenges involve other artists, your spouse, or members of your family following your death. We have looked now at Louisiana state law and federal copyright law individually, but what happens when the two laws intersect on the battlegrounds of a divorce suit? In divorce, and any other kind of case for that matter, when a principle of federal law overlaps with a principle of state law, federal law trumps or preempts state law. In other words, federal law has supremacy over state law covering the same issue. That's what happened when a Louisiana artist and his wife divorced, and a federal court was tasked with the problem of how to deal with the dueling principles of federal copyright and state community property law. The name of that case is Rodrigue versus Rodrigue. George Rodrigue and his wife Veronica were married 26 years, and during that time George rose to fame because of his paintings of the former family dog, Tiffany. Many of the images produced by Mr. Rodrigue during the marriage were granted copyright protection by the Library of Congress. Mr. and Mrs. Rodrigue divorced, and a major issue of the landmark case that followed involved the fruits of Mr. Rodrigue's copyrighted works after the divorce was final. As we have discussed, under Louisiana law, it's clear that proceeds from any paintings produced during the marriage, but sold after the divorce, were still community property. But with the blue dog iconic image, which was created and copyrighted during the marriage, and which continued to be reproduced and sold long after the divorce, were the proceeds of that work also community property? After all, every new blue dog painting is a new production, but it involves the same image conceived and created through Mr. Rodrigue's efforts, skill, or industry during the time he was married to his wife. There was no question that Veronica was entitled under Louisiana law to half the proceeds of the inventory generated during the marriage, but she also wanted half the proceeds of every blue dog painting that came after that, because the blue dog itself was a creation made during her marriage to George. The major roadblock to Veronica's argument was federal law preemption. Under federal copyright law, the copyright belongs initially to the author of the work. Under federal law, divorce did not change George's control of that copyright. But how did it affect George's economic benefit from the copyright? If George makes money through the management of his copyright, is that money 100% his? Well, under Louisiana community property law, the fruits of community property are also community. However, copyrights aren't property that just gets split up like chairs and tables when parties get divorced. George was going to always have management and control authority over these copyrights unless he assigned them to someone else, And Veronica, for as long as George holds those copyrights, wanted to get half the economic benefits derived from them. That put federal and state law on the mat, toe-to-toe, in the case Rodrigue versus Rodrigue. So you would think that a heavyweight like federal copyright law would clearly outclass Louisiana community property law, since in the theory of preemption, federal law always wins. Well, not in this case. Mr. Rodrigue's argument actually lost, sort of. Here's what the court decided. The copyrights George registered during the marriage allow him the exclusive benefits of reproduction, distribution, performance, display, and preparing derivative works based on the copyrighted material. But the financial rewards, the fruits, he derives from exercising the benefits of those copyrights belong to the community and must be shared with his spouse even after divorce. For as long as George Rodrigue holds those copyrights, the money he makes from them has to be shared with Veronica. So what could George have done to protect his interest in the funds generated by the famous Blue Dog paintings 26 years before his divorce, when he and Veronica first decided to get married? Well, not a whole lot, actually, since the Blue Dog wasn't created until about 1984, some 17 years into their marriage. However, once it became clear that George was hitting it big and the Blue Dog was becoming a famous image, he and Veronica could have negotiated an agreement that any copyrights he obtains in the marriage from then on out would belong to him, as well as any proceeds from the use and management of that copyright. In other words, he could have opted out of the community property regime. We spoke earlier about the fact that in Louisiana the community regime is the default for all married couples. But you don't have to have a community property regime in your marriage if you don't want to. You can create a separation of property regime which distinguishes your work and its fruits as your separate property. In that type of setup, you don't have to share the fruits equally with your spouse. You can also choose to have a partial community, partially separate marital regime, where you and your spouse specify which property you want to maintain separate from the community. Whichever regime you choose, you have to specifically contract with each other to opt out of the default community regime. You can do this before you're married in a prenuptial agreement, or during your marriage in a document called a Declaration of Paraphernality. So if you're contemplating marriage, or are already in a marriage and just want to change the rules as they apply to the fruits of your artistic labor, these types of devices will work. If you're planning for the end stages of your life, your focus may be on what happens to your property, including your copyrights after you've passed on. Certainly you can prepare a will, which sets out your wishes for the final distribution of all your property, including your copyrights. In Louisiana, you're free to will all of the property in which you die possessed. You cannot, of course, will property that doesn't belong to you, and that includes your spouse's share of any community property you had together, and the property to which your children, if they're forced heirs, have a claim. Forced heirship is a concept that still remains from our European-inspired past, but the laws concerning children who must inherit have changed considerably in recent years. Today, the only children to whom a part of your estate must go are those kids aged 24 and younger, or kids who are older but unable to take care of themselves or their property on their own. If you die with children over age 24 who are otherwise healthy and able to manage for themselves, then your estate is yours to will to anyone you choose. Another option for those planning the future of their artistic legacies is the creation of a foundation to manage your intellectual property after you've passed away. A noteworthy example of this is the foundation Andy Warhol created in his will. When Warhol died in 1987, his will established a foundation, the Andy Warhol Foundation for the Visual Arts. Warhol left the bulk of his estate to the foundation with instructions as to how he wanted it to function. The foundation manages his copyrights and trademarks and licenses the protected work. It then uses the proceeds of that licensing to fund projects which Warhol considered important. In the first 20 years of its existence, the Warhol Foundation built an endowment of over $240 million and reported planned cash grants totaling $11 million to fund projects nationwide. Certainly, Andy Warhol's legacy is food for thought, but whether you choose to manage your copyrights in a way that benefits yourself, family, friends, your local community, or even the national or international communities, you have the power now to make those decisions. With the information I have provided today, I hope you feel inspired to make plans for your future. If you're planning a wedding, think about the type of marital regime you and your future spouse would like to have. If you're already married, consider the benefits of a separate property regime. If you're considering divorce, consider how decisions you made in the past, or failed to make at all, will affect your future. And lastly, if you're considering writing a will, think about your family and the other people you want to benefit from your lifetime of work. Thank you for your attention today. If I can be of any assistance to you in making a decision concerning marital or estate planning issues, please feel free to contact me.